Welcome to the Latham and Watkins Forum on Facts, Pretexts, and Judicial Scrutiny of Executive Power. Welcome to the audience here. Welcome to the folks watching on Zoom. Today's discussion is co-hosted with the Reese Center on Law and Security. My name is Ryan Goodman. I'm one of the faculty co-directors at the Reese Center and a professor of law here at NYU. I'm honored to have with us really just a superb panel of great minds and thoughtful analysts to tackle this challenging question. And I thought to just first introduce the panel. I'm going to make a little announcement. It'll probably be the longest part of my introduction about CLE credits, because I have a script, and then we'll get underway. So just introducing the panel from myself down the side of the table. First is Judge Thomas Griffith. He's a lecturer at Harvard Law School and served as a judge on the U.S. Court of Appeals for the D.C. Circuit for 15 years, from 2005 to 2020. Rebecca Engber is a professor at Cardozo Law School. She was former counselor at the Department of State and is a senior fellow at the Reese Center on Law and Security. And Christopher Fanzone, Chris Fanzone, is the former head of the Office of Legal Counsel. He is the former general counsel of the Office of Director of National Intelligence. He is the former legal advisor of the National Security Council. He is the former special counsel of the Department of Defense.
I can't keep a job.
I was actually mentioning this to my students in the class right before this, and I said, and yes, that's one person. And also senior fellow at the Reese Center, and then I also get to very happily say is now also an adjunct professor here at NYU Law School teaching our students. So it's just really fantastic to have Chris in our community like that. And so let me just say the CLE introductory remarks. So I'm just going to read this verbatim. This event has been approved for one New York State CLE credit in the category of areas of professional practice. The credit is both transitional and non-transitional. It is appropriate for both experienced and newly admitted attorneys. For those seeking CLE in person, please remember to sign both in and out of the sheet by the door. We cannot issue credit to in-person attendees who do not provide their signature upon arrival and again upon departure. For those seeking credit virtually, I'll be announcing the code later in the program, and an attorney affirmation form will be circulated via email shortly after the event, period. So just by a few words of introduction to our topic, I think we're at an inflection point in the country in terms of the stresses on checks and balances, at least between the executive branch and the judiciary. And then I think in part of our discussion, we'll also talk about the role that Congress might play. And just to put some facts out there, so I don't want to put my own views out there, we did recently produce a major study at Just Security, and then we recently updated it in middle March, in which all we try to do is simply track what judges themselves are saying. I'm not trying to put any additional gloss on it. And what judges themselves are saying is since January 20th, 2025, in 90 cases, they have said and concluded that the government is not providing them with reliable, truthful information. And that does not include the recent surge of immigration detention cases, which accounts for another 75. So that's where we're at. And in that, it is either the judge themselves in the supermajority of instances reaching that conclusion, or it is the government itself making that as an admission to the court. And since our study, one of the most significant events also recently happened in the Southern District of New York, where the U.S. Attorney for the Southern District came to the court and said, this morning we were told by ICE that something we have represented to you for months is materially false. And that's about whether or not ICE had a particular guidance that would allow for them to arrest people at immigration courts. And they said, actually, we've been telling you for months that guidance said that was authorized. It does not say that it was authorized, and we were just told that this morning by ICE or that same day. And they admitted that to the court, and they said, it's like in all of our oral arguments, and it's in our papers, and we know that you, the court, had relied on it in your own judgment. So that happened after our study. So with that, I thought just to first open it up with Judge Griffith, and just to set maybe more of a baseline, like before January 20th, 2025, what are...
Was there a time before?
It's hard to remember. Yeah. So I guess the question is just to set a baseline of what's the normal posture of courts when it comes to the kind of judicial doctrines that give a presumption to the executive branch or forms of deference, especially in the national security context that we're talking about when it comes to representation of facts, and whether or not, in your view, that baseline set of rules was the right equilibrium at the time.
Right. So before I do that, can I thank you for inviting me here?
Thank you for being here.
I'll answer your question, but I'm grateful to be here. I play a role on panels like this around the country. I'm a token conservative that gets invited, but let me explain what I mean by conservative. I'm like old school conservative, right? Not what's used as conservative today. And today, I'm no longer a judge. I call myself a post-partisan conservative. So anyway, I typically, I'm certain I'm here because Trevor Morrison and I served on the Supreme Court Commission together. Again, I was a token conservative there. I'm happy to play that role as long as you understand what I mean by conservative. We're at a moment right now that actually Justice Scalia would have loved in many ways. You know, his standard stump speech was about the importance of the separation of powers. He would say, you know, every country's got a Bill of Rights. You know, the Soviet Union's got a better Bill of Rights than we do, but it doesn't mean anything because they don't have separation of powers. That was his standard. I heard him give that speech over and over again. Well, right now, we're living in a moment that the Trump administration is God's gift to separation of power nerds, right? I mean, we are seeing issues arise that I never confronted as recently as 2020. So I will describe to you how things used to be, and it used to be, I can't imagine having been in a time where 90 courts around the country made the statements that you've referred to. I'll get to some of those later, because I actually think some of them are a bit extreme. But anyway, still, nothing like that. Because the idea was, when the government comes before you, you trust them. You have a degree of confidence. There's a presumption that what they're telling you is accurate. I would tell my law clerks confidentially, okay, when we're preparing for a case, we don't necessarily agree with the government's view of the law, but you can trust their briefs. No, I tell my law clerks, learn the record as best you can. Learn the record as best you can. But if you don't have the time to learn it as best you can, the government, you can trust them. You can trust them. And that was based on a couple of principles. One is that's how they operated, and so you could trust them. Another is a principle of comity, that this is another branch of government coming to you, and you start with treating them with respect, and hopefully it's reciprocated. So, and there's also an economy reason to that, right? There's an efficiency reason. As a court, you can't know everything, right? And so you have to be selective about what you rely on and what you trust. And over the years, principle of comity, principle of judicial economy, and practice, you came to trust the government. Again, you tested their legal theories, and obviously if they told you the facts wrong, they told you the facts wrong. But you started with the baseline of, okay, these are honorable people making good faith arguments based on an accurate representation of the record. That's just how it was. Imagine we'll get into some national security issues later, but in national security, even more so, because one, the Constitution gives the executive power over more, not exclusive power, but a lot of power in that area. And plus, they know things that you'll never know, right? Because of the security aspect of it. So even national security issue was even heightened that you would do that. Once again, I don't want to say you roll over and play dead. You tested it all the time. But the baseline was trust and confidence based on those principles. Did that get close to what you were asking for?
Absolutely.
Okay.
Beck, can you talk about what, in some sense, we can just start to specify what's at stake here in the national security context? What are the kinds of consequences from that kind of deference that courts have traditionally given the executive branch when it comes to the invocation of an emergency or war or other similar instruments that the executive can pull?
Yeah, so I also want to take a moment to just thank you for having me. It's really great to be here, and it's also great to see some of my students' faces in the audience. So thank you guys for coming. So I actually, while you were speaking, it occurred to me that I had a question for you that maybe we can delve into more as we go along that relates to this, which is how much of that trust that you speak of was about assumptions that there were certain guardrails operating inside the executive branch, right? That there were certain processes being followed, that the policymakers were relying on a particular kind of expertise, the exact expertise you're saying you didn't have access to, right? So one of the things, and I think we can get into this later, but I'd be curious to know, because I've made assumptions about this, that courts are relying to some extent, or have historically relied in the deference that they're providing to the executive branch on the idea that the executive branch was going to be making these decisions through some kind of reasoned, considered process on the basis of real expertise.
Totally. That's part of it. We could trust them because of experience. You learned over time that no, they're doing a good job.
So that's relevant to a lot of things that I'm thinking about. But to Ryan's question about the consequences here. So, at a broad level, when we talk about deference or all of the different doctrines you mentioned that lead to, sort of a thumb on the scale for the executive branch, we tend to think about this as between the courts and the president. But it's really a question about the extent to which all three branches have a role to play in decisions about whether it be about emergency powers or national security or literally anything else. Because when Congress legislates, many of the things we're talking about are statutory authorities, and when Congress legislates authorities and constraints on those authorities, it relies largely on actors within the executive branch and courts to enforce those parameters. And so when actors inside the executive branch are not undertaking those processes and actually relying on their legal advice to give good faith interpretation of those statutes, or if they don't do that, courts don't step in, then I think that's also cutting Congress out of the equation. So it's not just about the president and the courts, I think. But to the practical effects of this, like just to think about what the consequences are, what the decisions that we're talking about, when we think about wartime authorities, I think we often think about whether or not the president can use force without Congress, right? We think about Iran. The president goes to war without congressional authorization. Is that legal? Is that not? And in that case, of course, as we know, the legal determination the president's making is not that there's a war. The legal determination that the president's making is that it's not a war, and he's claiming authority on that basis. But there are all sorts of other areas where the president claims wartime authorities that have all sorts of impacts that don't necessarily have to do with just using force against another nation. So, for example, in just the past year alone, if we just look at this year, the president has rounded people up on the basis of a legal theory that we have been invaded by, that drug trafficking itself is somehow an invasion, that we've been invaded by these drug cartels that are being sent by a foreign nation, has rounded people up, detained them, claimed the authority to then ship them off to a foreign gulag with no process, regardless of what their status is or whether they have any authorization to be here, on his sole determination that they are members of this group and that we have been invaded or there has been some sort of predatory incursion on the United States. And that is subject right now to active litigation. Many judges have pushed back on the notion, but they've done so because they've been interpreting the words of the statute, and because of the way the president's arguments have gone, they've been able to say, well, the president is using invasion differently, that we're using invasion, and so we can stop it there. But they have left open, and it seems to me quite plausible, that most, if not all, of the judges who've looked at these cases and will look at these cases will accept a presidential determination on the facts alone that we have been invaded. The president just says, there is an invasion, I know it, you might not have seen it, I'm basing this on my own intelligence or what's in my gut, and the courts cannot review that. And so that's one of the things that's at stake here, right? Another, on similar legal theories, the president has been killing criminal suspects at sea. on the theory that drug trafficking is an attack on the United States, that we are at war, we're in an armed conflict with numerous unnamed drug cartels that the president and his lawyers have established in secret memoranda. And on that basis, and the executive branch's sole authority to determine who's a member, who's not, and what their activities are, the president has been killing criminal suspects at sea for actions that we don't even have the death penalty for if they were actually tried and convicted. And the president has threatened to send the U.S. military, U.S. forces into U.S. cities on a theory that would require some sort of presidential determination that there was a rebellion or an insurrection. So these are what we know. But I also want to point out that there's a lot happening. We know from history that there's a lot happening under the surface that we don't necessarily find out about in real time. So historically, presidents have made other claims. Presidents have made claims that have been public, like the claim to be able to seize the steel mills, right, in the Korean War. But presidents have also made claims that were not public at the time, like the claim to be able to surveil Americans inside the United States on the basis of the war with Al-Qaeda. And we only found out about that many, many years later. And only because internal executive branch officials were willing to put a stop to it. So I think it's fair to say that we can't necessarily know right now the whole range of authorities that the president is claiming an ability to take based entirely on his say-so that we're at war or in an armed conflict or some other factual determination that's similar.
So that's a great segue to, Chris, what I wanted to ask you about and have you wear your former OLC hat first, which is what you see as the kind of proper role internal to the executive branch when these questions come up of factual determinations or assessments, especially in the context of national security where everybody inside knows that there's a very good chance it's not going to get to the courts, or if it gets to the courts are going to, generally speaking, defer to the executive's factual determinations. And what's the proper role of lawyers in that instance? What's the proper role of the Office of Legal Counsel? I'll throw like one kind of concrete example just to concretize what I'm thinking, but you could riff on other examples that you might want to give. But if the president says, I, as the president, have reached a factual determination that some drug cartel is engaged in an armed attack against the United States, or I, as the president, have reached a factual determination based on the intelligence that Iran poses an imminent nuclear threat, which seemed to be what the DNI was saying before Congress, that she just defers to the president. It's his call on that. What is OLC supposed to do with that? What are lawyers supposed to do with it? If it's a presidential statement as to that's the final say-so, especially if we're in a unitary executive kind of approach to it, or not? How would you advise lawyers to deal with that? How do you advise, like, what is the right and proper approach?
Sure. Well, I'd like to start off by taking the novel step of thanking you for having me here. and also, it's great to be here with the other panelists. It's great to see some familiar faces out in the audience, so I'm really happy to be here to talk about this important topic. I guess I'd break your question into a couple different parts. The first part, and I think is by far the most straightforward, and this is actually sort of like office doctrine. There's a memo, I think it was written in 2010 by David Barron, who at the time was the head of OLC, who's now a judge on the First Circuit, laying out the office's best practices. And in that memo, he notes the office always tries to get it right and wants to do a diligent job to try to find the right answer. But it notes that they have a particular responsibility to do that in cases when the courts are either going to be reviewing determinations with highly deferential standards or not at all. So a lot of what the office does, courts don't review at all. A lot of it is reviewed under the deferential standards we talked about. And I think in those cases, the office's doctrine is you have to particularly try to do a good job. And I know just from sitting in that role and sitting in other roles where this is the case, you really feel a weight a little bit more when you know that you're really the lawyer who's going to be reviewing this, and courts aren't going to be reviewing it in quite the same way. So I think that's pretty clear. Then how does that manifest itself? Is that really just about the law, or is it about the facts too? I've always thought, and I think that this is pretty consistent across people I've talked to, people I worked with, and it's actually one of the first things I would tell folks I worked with when they came to work at OLC or came to work with me at ODNI, is the most important thing you can do when you're giving legal advice is to make sure you know the facts. And there's a couple reasons for this. One is that I think people don't remember the specific legal moves you make when you sign off on an executive action. They remember what the executive branch actually does. They remember the facts of what happens. And people don't say, well, if the executive branch ends up doing something that 6 months later becomes public and the public looks back on, why did we do that? They don't say, well, here are the specific technical legal moves OLC made. They say, like, how could you have said that the president could do that? So that's the first thing, is like that's just kind of these issues where the legal doctrines are broad, they provide a lot of discretion, the facts are actually super important. I think secondly, the executive branch generally, in the way it practices law, is pretty methodologically minimalist. I think they'd like to decide issues narrowly, they like to decide issues on facts for a host of reasons. One, they're not a court, the courts are gonna weigh in separately. Two, the world is a complicated place and situations change, so you don't want to make broad sweeping legal pronouncements because you might be either precluding or allowing stuff that down the road might seem very different. So I think the executive branch is very methodologically minimalist usually. So I think that the facts are really important. And the third thing that I think is at work here is that the executive branch, and Dean Morrison's written about this, is that is information advantage compared to the courts. The courts now, we'll have a discussion later on about what courts can do to find facts in the executive branch, and they have ways to do that. They can ask questions. They can receive evidence that allows them to get the facts. But when you're at OLC, you can pick up the phone and call the general counsel of the Office of the Director of National Intelligence. I've been on both sides of these phone calls and say, hey, can you have your experts on issue X come and brief us on the facts here and what you're trying to accomplish, and we have questions you want to ask. And you can have a conversation with them. You can ask them follow-up questions. They can come back and respond to those questions. You can really get pretty deep on the facts. And my experience has always been that when policymakers want to do something, they're more than happy to allow lawyers to make sure they understand the facts and understand what they're weighing in on, which I think leads to your last question about deference to the president. I mean, I think Ryan, you and Beck have both served as lawyers in the executive branch. You know you're not the president. The president has the ability to make these determinations. Ultimately, if the head of OLC says, I don't think these are the facts, and the president disagrees with you, that's the executive branch's determination. You face choices about what you're going to do in response to that, which we can talk about. But, I mean, my experience has been that you have a responsibility when you're a lawyer. Usually issues bubble up from people who are planning them up through the lawyers to the president for a decision. And in that process, you have a responsibility of at least probing whether the president could reasonably decide that these are the facts at issue. And what does that mean? It's obviously a squishy standard, and it's going to depend on the specific nature of the facts. But you're not going to, if the factual determination was the sky has to be blue to do this, and the president determines it's green, so we're not going to do it, you would obviously say, well, that's not the case. I mean, it's that type of thing, and it's obviously more searching than that. But the lawyers have a responsibility to make themselves comfortable, that they know what the facts are, and to the extent there's any predicate determinations that are based on those facts, the president can reasonably describe them, could reasonably make that determination. You know, there's some wiggle room there, and I think certainly a tie would go to the president in that case, but it doesn't mean you kind of just accept whatever the president says as the gospel truth when you're doing your legal analysis.
Thank you. So I'm going to start a second round of questions, but I failed to mention at the beginning, I just thought to mention it now. There are 2 microphones in the room. They're there for a reason. At the end, there'll be time for questions from the audience as well. Judge Griffith, I wanted you to then just invite you to speak about what you do see out there across the courts. You mentioned that you think some of the courts have maybe overcalled it or exaggerated their concerns. Their concerns are exaggerated, or they've expressed it in an exaggerated manner. So just to invite you to talk about that. Sure. Is the system, big question is is the system holding? How are the courts dealing with the stress? And if it's in a bad situation now, what would you think is the way to get to a better equilibrium?
Right. So I think the courts are doing well. Now, I'm biased here, right? I mean, I'm coming from the judiciary. I'm proud of the federal judiciary. I think it's the crown jewel of our democratic republic, and I think it's doing well. It's not perfect. The other thing is we're only in like the 3rd or 4th inning of this, right? I mean, and so let's come back and talk to me in August and see how I think things are going. But right now, I'm okay. I'm okay with where things are, generally speaking. On the idea that courts are deferring, the courts historically have deferred to presidential determinations, particularly in national security areas. I think there's another reason for that. And this may sound naive, but traditionally, those aren't judgments, national security judgments, aren't judgments we want the courts to do. We want politically accountable representatives to do that. If people are going to send young Americans to die overseas, we don't want judges involved in that as much as we want people that we can vote for or against to do that. We want politically accountable representatives to do that. So I think that's one reason that courts have deferred so much to the executive and aren't willing to say, well, invasion, I don't know. You think it's an invasion? What's invasion? You think it's a national emergency? Courts have been reticent to get into that area. This administration may force them to do it, but they've been reticent to get into that area simply, I think not simply, but one reason is because traditionally we have thought these life or death national security decisions are to be done by politically accountable representatives and not the courts. I did make that side comment that I think some of the district court judges have let me put it this way, I have to be delicate here. The Chief Justice in the Commerce Department case made I won't be able to quote, but a great line in effect saying, hey, we don't need to put our heads in the sand, right? We don't need to be naive about what's going on as we evaluate the lawfulness of executive action. I'm not exactly certain I like that. I'm not exactly certain all that means, and I'm not certain what principles you derive from, but he's generally, what he's saying, he's signaling that we see that there are unusual things going on in this particular administration, and that's not a controversial statement at all, right? We have a president who governs in a very, I'll be generous, unique style, right? Unique style. And so the Chief Justice has signaled to the courts, pay attention, pay attention, something unusual is going on here. There's something else unusual that's going on that I think some of the district court judges should pay a little more careful attention to. And that is, this is a particularly polarizing president. And it's really hard, I don't know about you, it's really hard for me to look at these issues in the abstract. It's really hard. The only way to do that, and you're law students, you're learning how to do it, is to switch the particulars, right? To switch the principles. So now it's your favorite politician is doing this, and how do you come? That's a tough thing to do. I'm afraid when I read some of these district court opinions, it seems like they have forgotten that a little bit. Some of them have. I think they've taken the bait in some ways, and they've said rather extreme things because of the personality involved. And here's what's wrong with that. First of all, it's not in keeping with judicial temperament, but here's what's wrong with that. And now I'm going to move into political science mode, about which I know nothing, but I'll give you my 2 cents worth anyway. The narrative that's coming out of the Trump administration right now is rogue district court judges, unprincipled district court judges, right? Resistance district court judges. They want to impeach them. They talk about a judicial coup and this sort of stuff. And when district court judges or appellate court judges use extreme rhetoric, extreme language, for example, one comparing deportations to the slave trade, don't do that, because what you're doing is you're playing right into the hands of those who want to argue that the courts are just partisans in robes. And so I think it behooves courts to, as best you can, to kind of calm down in this motion and try and be as neutral obviously in the application of law, but in the application of rhetoric and explanation of it. Don't give those who say it's all a partisan process, don't give them a tool to beat you over the head with it. And I fear that a number of the cases have done that, and they should. So there are 2 realities that I think judges need to take advantage of, take a look at. One is, this is a highly unusual way to run an executive branch, right? And 2, you're talking about a really polarizing figure. And so when you're writing about that, you have an extra obligation to prove to the public that you are not being partisan. I'm not filibustering now, but can I tell a story that
Please,
I'm the hero of the story? I'm the hero of all my own stories. So the very last opinion I wrote on the D.C. Circuit, I mean, literally the last opinion I wrote, it involved in a case with General Michael Flynn. I don't know if you remember him. He's still around. But we had a case. He was going to be prosecuted, and then a new attorney general came in and decided not to prosecute him, and there was a legal controversy over whether that could be reviewed, and it ended up in the D.C. Circuit, and it turned on just the most boring, uninteresting issue. And I won't even explain it to you here, but it was like this really highly technical procedural issue. And yet, there's no way that General Flynn and his supporters were going to see it that way, because he lost. There's no way he's going to see it that way. Well, this is my last opinion, going out the door, you can say what you want to say, sort of thing. And so I actually took some time to say, look, I know what people are going to say about this opinion. They're going to say, it's a bunch of people after General Flynn. I didn't use such colloquial phrases, but I said, but that's not what's going on. Here's what's going on. And I went through this. It's a highly technical procedural issue. Now, I can't imagine that General Flynn's folks read that and said, oh, okay, we get it, Griffith, we get it. But I do think that sort of, I think there is a heightened obligation in this atmosphere with the rhetoric that's flying around now, the arguments you're making now, that the judges go the extra step to make certain, to show their work, to show this is not being driven by my animus towards a particular person and the way they govern, but it's being based on law.
Yeah. Chris, did you want to weigh in on
Just
two?
in this, I'll just make one observation, then we can continue, because we might come back to this later. I think the point the judge made about the comparative sort of institutional legitimacy of the different branches and who we want making certain decisions is a very important one. I think one thing that's really interesting, and I saw this when I was in the executive branch, the sort of what the ambit of what is considered national security is increasingly increasing, and I think that makes those questions harder. And like going back to Youngstown, I think one of the things that made Youngstown such a unique case is that taking over the steel mills affected the entire country and workers in the country. It wasn't something that was just happening overseas. And I think when national security authorities are used to impose tariffs that affect almost every transaction in the country or deploy the military domestically, I think the considerations are still relevant, and Congress still enacts statutes that gives the president some degree of discretion, but I think the considerations and the balance of considerations may change. And
So can I ask? You're exactly right. So the national security card is the card. Yeah. So I at one time I was the chief lawyer for the United States Senate. So I'm going to say you guys. So that's what you guys would always do. Everything. Play the national security card, and you win. You win. Okay. Now, how comfortable are we telling the courts to say, get involved in that and say, no, that's not national security? I mean, we saw that in the tariff case a little bit, but I don't have a view on this. These are the experts.
Well, can I jump in on that a little
Yeah.
bit? Because I actually wanted to push back just gently on the idea that this is about unelected officials versus elected officials when the courts decide to defer to the president, because there's another body of elected officials here, right, which is Congress, which goes back to the point that I was
I
trying to make.
forgot.
Yeah,
We have
I
a
know.
Congress.
I know,
Oh,
and
funny how you
look,
forget
as
that.
a former executive branch lawyer myself, we often like to cut them out of the room also. But now that I'm on the
Just
other
so
side,
many of them.
there's so many of them. And so, at times when the court is when the court defers to the president because they say, well, unelected judges shouldn't be making this decision. We're not going to decide what an invasion is. We're not going to decide what a use of force is. We're not going to decide what a war is. And we're going to let the elected, we're going to decide that this is better left to the elected officials. What that really means is we're going to decide this is better left to the president, not to Congress. It's not actually a decision between unelected and elected. It's a decision between two different elected bodies. And a lot of those questions about war in particular, the Constitution actually gave to the other elected body, right? To Congress. And it's pretty easy in terms of institutional competence, it's pretty easy to say whether there's a declaration of war. That's an on-off question, right? And so, for example, in the Alien Enemies Act litigation, sure, the courts could say, look, we haven't been invaded, it's self-evident. We were ready to defer to you, but we're actually going to we have to take some judicial notice of just the sky being up there in the sky, the sun being up in the sky's blue, not pink or whatever. And so in this case, let's say they say, look, there's been no invasion, and the elected officials think, well, that's just clearly wrong. We actually need to be able to use wartime authorities. There's a very easy,
Exactly.
immediate remedy,
Yeah.
which is that Congress declares war,
Declare,
and then
yeah.
the Alien Enemies Act kicks in, right? And so it's not necessarily this, this parade of horribles that unelected judge is going to take over our national security system simply by enforcing the constraints that Congress has actually created.
I vigorously agree with everything that you said. That the problem here is that we have a Congress that's not doing its job. And then the question becomes, maybe it's a related issue, so does that change the nature of what the court's responsibility is? And
There's a chicken and egg here problem
Yeah,
here to me,
yeah,
because
yeah.
if the courts don't let Congress play their role, right,
Yeah.
and cease to enforce congressional statutes, then I think Congress cease to, they sort of those muscles atrophy,
Yeah.
right? And so they don't feel like they have an obligation. The public ceases to look to them as having the obligation to take on those roles, and so then they don't give anything to the courts to work with, right? And so, we have to break the cycle somehow.
yeah,
I guess I would say, I don't know if, I don't know if the point I was making, I think it's a fellow traveler with Vex, but I'm not sure it was the exact same point, was even suggesting that courts could get more involved without changing their role. I mean, going back to Youngstown, I think courts have been more willing to second guess executive determinations when they had a domestic effect. And as the sphere of national security increases, the courts can maintain the same role. It's just the mix of cases before them that is different. And I actually think there's a legal cost to not doing that, beyond whether the executive gets to do stuff they shouldn't, is that it makes these cases get resolved in odd ways. The tariffs decision is perhaps an example of that. You read, there's the paragraph in the facts section of the Chief's opinion where he talks about the presidential finding, and then he talks about all the after the tariffs were first put in place, all the changes the president made. And he doesn't say this explicitly, but I think the sort of undertone of it was that the way I read it was basically, it doesn't seem like Congress intended the president to be toggling these tariffs in this way. And so what is the court faced with in that case? It has two ways it can go. One is it can say, the factual determination, and I can't remember the exact standard, but it's basically something like an unusual threat. It was an unusual threat that required putting tariffs on every import in the country. Or it could say that, I think the language is like managing imports or something like that, or I can't remember the exact language, is beyond these tariffs are beyond the scope of that text. And that was a tough question of statutory interpretation, which is why the court was so all over the place with it. I mean, would the court have come down the same way on that text if the president had put a very targeted tariff against an adversary nation who had taken Americans hostage overseas? I'm not so sure. But now for the rest of history, the president's not going to have that authority. And so being afraid to tackle the facts, or not being afraid, but being deferential with respect to the facts, leads you to making legal determinations that perhaps could have been resolved more easily in a different way. I'm not saying the court did the wrong thing in the tariffs case. It's just, I think it creates puzzles like that.
Yeah. Judge Griffith, I wanted to go to a thread that you had put out there about that courts traditionally did give deference to the executive on national security type issues. And I think your language is something like, but now the administration has forced them to reach those kinds of questions more than they ever did before. And so in a certain sense of what you think the dynamic is there. So part of what I've seen in the dynamic that I do not think has received enough attention is actually before the courts, this executive branch is actually asking for maximalist authority. In fact, if you just started to do a list of what is on their wish list of what executive power should be and what they're actually saying to the courts, one of the most extraordinary ones was the oral arguments before Judge Breyer in California on the federalization of the Guard. And the DOJ lawyers say to the judge midway through, our argument is that the president didn't need to have any evidence when he said that it was the basis for invocation of the federalization of the Guard. And Judge Breyer says, sure, you don't mean no evidence, right? You don't mean no evidence. They said, no, that's our view. Our view is the president gets to make that determination exclusively on the basis of no evidence if he or she so decides. And obviously that's not the way that the judge came out, it's not the way the Court of Appeals came out. So is that part of what you're talking about in terms of forcing it?
Exactly.
Yeah.
Yeah. So I'm with scholars, so I'm careful here. You all correct me. But my perception is what we're seeing is we're not seeing any like totally new arguments. These arguments have been out there, but they haven't been made by the government before. They've been made in law review articles, people, junior faculty trying to get tenure and stuff like that. So they've been out there, but now they're being made by government lawyers. And so I used to teach a class on presidential power. When I first got on the D.C. Circuit, I thought, I really don't know a lot about this, so I taught a class at a law school about presidential power. So I'm now going to tell you what I learned teaching presidential power in 4 years. So you don't have to take the class, okay? We really want a king. We actually do. The human nature wants a strong leader. I mean, if I were to announce that I was running for president, don't worry then. And I said, okay, here's my platform. Here's my platform. I'm running for president. In the first 100 days of my administration, your mind's already racing on what I'm going to say. Here's what I'm going to do. I'm going to sit down with every leader in Congress and every civic leader, and we're going to talk for 3 months, and we're going to find some common ground on which we can go forward. None of you would vote for me, because we all want a person of action. And I think it's probably true. I don't think there's been a president since Calvin Coolidge who didn't try and expand the executive power. They've all tried to expand it. But now we've got someone who's trying to expand it to the nth degree, and this is new to the courts. My prediction, I'm not good at predictions. What's the Yogi Berra line? I'm not very good about predictions, especially about the future, but my prediction is this type of argument that you just referred to is not going to be well received on First Street. John Roberts, whatever you think of him, I think he's a great Chief Justice. Whatever you think about, is an institutionalist. He was a Department of Justice guy, right? Brett Kavanaugh is an institutionalist as well. And his confirmation hearings, what's the two opinions he held up as the greatest opinions in the history of the Republic, or Brown v. Board of Education and Youngstown, right? These are serious people. Justice Alito, Justice Department guy. I'm reading their minds. Haven't had conversations about this, but they can't be amused by these sorts of arguments. And so that's why I say it's in the third inning, fourth inning. Let's see how this plays out. Let's see what happens. Let's see if those arguments are actually made to the Supreme Court. I mean, the Solicitor General has been very selective in terms of the cases that he's sought cert on. A lot of the cases out there where some of the more extreme or maximalist positions taken, he hasn't touched them. He hasn't touched them. So I'm hopeful. I'm hopeful that some of the shock that we're seeing from these arguments that were once confined to law review articles and now being made by government lawyers, I don't think they're going to go over well. And I'm just mimicking Jack Goldsmith's approach. Jack's pretty favor of muscular executive, but he says, "Oh my gosh, they're going too far here, and it's going to hurt them." We'll see.
So maybe first with Chris, and then Beck, if you might talk about the implications for what might become of the following, which is, if we're just observing a phenomena and Chris, you've helped me think through it in these ways, which is like on the retail basis in individual cases, judges are now starting to say very explicitly, in the case that's being presented before me, there's such misleading information that's being given and the like that I cannot bestow upon you the presumption of regularity, and that there's the presumption of like good faith, and that's the presumption that things that you're presenting me are truthful and the like, or not giving the plaintiff's discovery because we just presume that the government's not engaging in certain bad practices or irregular practices. And in that individual case, on the retail level, the judge is saying the government has forfeited the presumption. But on the wholesale level, there's some judges that are now starting to say very explicitly what's happening out there in the country, the fact that this is happening at a more system-wide level, means that when you come into this court, that the government has forfeited its presumption of regularity across the board. It's not that you just have to prove it to me in this case. I know what's going on. I know the 90 cases. I know the plus 75 other cases. And some judges have said, like the president has forfeited, appears to have forfeited this within the first several months of the administration. And do you think that that's just an observable phenomenon? That's the direction things are heading in? That's the trajectory? Do you think that's the right approach for these courts because they're actually making determinations based on things that are actually happening outside of the court case before them? And then for back after Chris talks about that, if you could also talk about what the implications might be for the government losing a presumption of regularity, would be great.
So I'm not going to have hard and fast answers to this question because it's such a developing situation. I think Judge Griffith makes a good point that we're so early and things are evolving and different, what's happening, a lot of what we're talking about is happening at the district court and the Court of Appeals level, and things are proceeding differently at the Supreme Court. I don't think there's any question about that. I think, as you laid out, and this is an observation that your study shows, not that I came to independently. I think the way the presumption of regularity has historically worked is it's a presumption in an individual case where the judge, for the reasons that the judge described earlier, judges tend to accord some deference, accord a presumption that what the Department of Justice is telling them is accurate. And then if in that case some reason arises to question that, they ask more questions about that in that case. I think the thing that was interesting in the information you provided in your presumption of regularity study is that some judges are making broader claims that, kind of a fool me once, shame on me, fool me twice, shame on you type thing, where this has now been 2 or 3 cases where this has come up, and I'm gonna, anything the government's doing, cast a little bit more of a stare at it. I think that's inevitably going to happen. If you're a district judge and the Department of Justice in the 2 prior cases comes in and says something that they later, maybe it wasn't malicious, but they just made a mistake and they came in and said confessed error. In the 3rd case, you're going to probably ask them a couple of questions just to make sure you got it right, and that's probably inevitable. I think it's tough to, and this is something that I think folks are going to have to think through how to sort of implement that, how to theorize that, and how courts should do that, if they should do that, and and how they would do that. But I think it's inevitable it's going to happen, particularly in courts that have seen this quite a bit, like I think the DC district courts is probably being one of the areas. I think the thing that's interesting about it is that deference and presumptions work both ways, in the sense that I think if you're going to be more searching about what the executive branch does when they misbehave, whether intentionally or probably unintentionally in most cases, then I think you also have to be willing to give them deference when they behave better. And that's something else I think people need to think about. What are the conditions that either this administration or a subsequent administration can do to show that they're going to behave differently before the courts and therefore should be accorded the presumptions that are historically afforded to them? Because I think we don't want to create a situation where it's a one-way ratchet. I don't think that's good for the courts. I don't think that's good for the executive branch. I don't think that's what Congress either intended either.
Right. And so, Beck, if you could talk about what might be the downstream consequences if judges approach this from the more wholesale angle. On the, one counterpoint might be, no, it's actually, that would gum up the works of government, its ability to function, its ability to litigate, its ability to defend itself, its ability to bring criminal prosecutions against claims of selective prosecution and the like. So what do you see as the potential downstream trade-offs?
Well, yeah, I mean, certainly the executive branch has long sort of tried to raise alarm about what would happen should courts not defer or should courts not leave the determinations to them. And I recall back in the post 9/11 days, there were a lot of arguments that granting habeas to detainees, for example, who were being held at Guantanamo or even on U.S. soil, even American citizen detainees, would completely hamstring soldiers' abilities to operate in the field because they'd have to figure out who they were detaining or actually collect evidence or retain evidence. And that, I think repeatedly we have seen the executive branch make these arguments, and when there has been pushback, when they've been forced to sort of provide a little bit more information to courts and go through the litigation process and have that sort of spotlight shown on what is happening, that has this parade of horribles has not come to pass. I'll just say. I know we're short on time, so I'll try to be brief. I just, to Judge Griffith's point about there being a trajectory of this is not a new issue, right? As you pointed out, the executive has long tried to make claims to power when presidents have felt they needed to do so for whatever reason, and the framers expected that, right? The question then is what's happening with the other branches? Is there sufficient pushback? Are the other branches fulfilling their role in trying to push back? And it is possible that Congress has not, in particular, has not been doing that, especially of late. And so when we think about deference and what the downstream consequences would be, I think Chris is absolutely right that we don't have to think of this as an on-off switch. Deference can be conditional. And so one of the things I've long thought about is the fact that when courts tend to defer, and this goes back to the question we were talking about earlier, when courts defer to executive branch processes, in part, they are doing so based on this assumption that there is some kind of reasoned process happening, that it's happening on the basis of expertise, and that the executive branch is a more accountable actor because these are elected officials, right? All of those are things that you've mentioned as guiding your reasoning in terms of when you would want the executive branch and not courts to weigh in. And yet, it has not been my experience that courts necessarily look behind the decision that the position that they're getting in court to find out whether any of those traits have actually been in play. So at times, courts may think they're deferring to a reasoned executive branch decision, but they're really deferring only to a litigation position that the executive is taking in court because they want to win the case. Or they may think they're deferring to expertise and accountability, but those are traits that are actually taken on by totally different actors inside the executive branch. So accountable actors are the ones, sort of at the top. Do you want to get, and you could actually incentivize having accountable actors involved in the decision-making process by, for example, requesting affidavits, to suggest that they've been involved. If what you actually are trying to defer to in a particular instance is expertise, you might want to know whether the decision was based on the expertise or it's just the president's gut, for example. Yeah. And those are totally different. Those are different traits that are actually sort of taking place within different parts of the executive branch. And so I think that conditioning deference on what you're actually being given, on some showing by the executive branch about even just who is involved in the decision-making process, could incentivize. And it doesn't have to be, you have to do this, right? It doesn't have to be a requirement. It could be, if you want the deference that we're inclined to give you, you have to give us some information about where this is coming from.
And we saw some of that in the Department of Commerce case. I mean, I think that's really what the chief was getting at. He's saying, well, wait a second. You're telling me one thing, but I know that something different happened. And I'm all for that. I think those are all great recommendations, but that's a very different world than we've ever occupied before. And maybe it's the world we need to go to. If the executive branch over time spends its trust capital, then maybe we need to go to a world where we're probing. But in the past, that hasn't needed to happen because there is a sense that good faith is taking place and reasoned decisions taking place. Now, for judges who say take the wholesale approach and just let's get rid of the presumption of regularity, I think that's a mistake for them to do that. Now, but having said that, I can't speak for any other judge. Okay, can't speak for any other judge, but I can speak for this judge. Okay, and I was a judge during the first Trump administration, right? And there was a lot of procedural irregularity there. Did I say irregularity? Yeah, procedural irregularity there. And that affected my thinking. When I'd get something from, that was involving one of the agencies, I wanted to make sure that what the processes were followed. And we looked a little more carefully at that because there had been a track record of not following procedural regularities. Now, I didn't speak about it in terms of presumption of regularity. I didn't talk about it. I didn't write about it. But just sort of common sense tells you if you've got that third lawyer in front of you after the other two have messed up, know that you're going to be interested in that. You're going to be interested. I think it'll be more effective for the judiciary if they do it on a retail basis, for the reason I'm talking about. If you just say I can't trust anything that comes out of this administration, the rhetoric of that hurts. Plays into the political drama, and I don't think that's good for the courts. But no, there's no question. I like all of your suggestions. I don't think we're there yet, but we're headed there. We're headed there. And to me, I keep saying in the third or fourth inning, I'm really interested to see how these cases eventually play out in front of institutionalists like John Roberts and Brett Kavanaugh. I'm really interested to see how that plays out.
Yeah, and actually, also, as I tell my students, like, the law is not static, jurisprudence is not static, and the world in which we might be entering is one in which they will help shape and define it, because there are these challenges to the system, and the system has to respond in new ways, because so much of this is unprecedented. And even I think so much new jurisprudence is being created around deference and non-deference on the national security ground, et cetera.
If Judge Posner would here, he would add an interesting thought. He would look at the labor dynamics here, and he would say, oh, you go that way, it makes judges' jobs a lot harder. That's why I loved Chevron. Oh my gosh, Chevron allowed me to spend a lot more time with my grandchildren than judges in the D.C. Circuit do today. So.
I think the interesting dynamic is, I mean, this is the phenomenon we're talking about is not just about litigants before courts. This is just sort of human nature. I mean, when I was in the executive branch, there were intelligence briefers who I trusted more than intelligence briefers I didn't trust as much, and the ones I didn't trust as much, I would ask harder questions, and I would ask a different briefer to come in and brief me about the same issue to make sure that we were getting the right. I understood the facts better, and it's sort of the same phenomena. I think the thing that's interesting, and the tension here is, since that's human nature, is that something that you make articulate, or is it something you don't? And I think there's reasons why you would, there's reasons why you wouldn't, and I think that's true of a lot of these things. That's true of the tariffs case. Like, do you proceed on a legal basis when some of your underlying concerns are more sort of factual on how it's being implemented? There's reasons to do it, there's reasons not to, and those are challenging cases. And as you said, Ryan, I think how this is going to develop over time, because it's such a fast-moving. The law is pretty slow-moving, but the sort of dynamics of the situation are very fast-moving. So I think we're going to be learning stuff as we get into the third and fourth and fifth innings, and some relief pictures come in and stuff like that.
And if I had all power and we were writing on a blank slate, I would do all of those things that you suggested. I would do all of those things.
As Jack says, this is an in some ways, overreach is an opportunity, right?
It would create far more accountability in the executive branch. Now, remember, I was the Senate's lawyer, so I'm not an executive branch type. So I would favor all those. But we're not writing on a blank slate, and we got certain norms that exist, and so I'm cautious about that. But I wouldn't be unhappy if we moved down that way.
I just have one question. Does anyone ever run for Congress being like, I want to spend my first 100 days just deferring to the president, letting him do whatever he wants?
Well,
It's implicit.
I think we have seen that. Yeah.
So I actually do want to pivot to Congress and then open it up. So just want to do one just prompt to you, because it's come up every now and then in the conversation, Congress. And what can Congress do specific to our topic of better ensuring that the executive branch is making appropriate factual determinations when it comes to national security, the kind of role that we're talking about the courts playing, but what is the role that Congress can be playing? When we're saying that Congress is not playing the right role, then what should Congress be doing? And I think each of you come at it from different vantage points of having either worked in the Senate or having exclusively worked in the executive branch. You maybe know some of the dirty secrets in the sense of like, what is it that Congress really can push forward with just mere exercises of hearings or other forms of oversight? So just to let you all play that out in terms of what you think the right role is for Congress that we're not seeing.
Yeah, I want to hear you all talk about. I want to hear you all talk about giving Congress more power. This will be fun.
I think Congress has a lot of latent power that it can use that it often chooses not to. Obviously, I'm sure others will talk about what statutes can be amended in which ways, or what sort of framework legislation we passed asking for more search and review. I think just as a practical matter, that's going to be difficult given how closely divided the country and the Congress is, and the president will almost certainly veto any of those bills, particularly when they're dealing with pressing issues that are political issues now. But Congress's softer tools actually, in my experience, have an enormous impact on the executive branch. And that goes from stuff as simple as just like using their voice in their bully pulpit and sending letters and making things, expressing views to, and that's really what I think is going to happen largely in times of unified government, to when you have divided government, holding hearings, Congress can actually pass legislation in those cases. It will be vetoed, but I think those things definitely have an impact in a couple ways. One is they directly impact the executive branch because particularly if it's members of their own party who are raising concerns, I think they're going to take those into account. But even if not, they see how a co-equal branch of government is thinking about things or key members of a co-equal branch of government. And then when you start doing things like oversight hearings and things like that, they actually have a salience, a broader salience that I think, like all things that affect public opinion, have a thermostatic effect on executive branch action. So a lot of Congress has often been very, very successful in bending the sort of arc of executive branch performance through ways other than legislation. And I think in national security in particular, issues that tend to be of high public salience long before legislation changed things, in things like the Vietnam War, in the recent wars in Iraq and Afghanistan, some of the, both strategically in terms of the direction the executive branch was taking and the particular tactics that were used. I think congressional concerns had a big effect on how the executive branch acted.
I would ask, I'm sorry, I ask both, when you all were in the executive branch, what did you think of the Senate Intelligence Committee, for example? Was it a welcome partner or a nuisance or?
Yeah, I mean, it was both, of course.
Yeah, yeah.
But I think and just some of the audience might not know, the Senate and the House have select committees, which are sort of special committees that are set up to oversee the intelligence community, because the intelligence community, like the vast majority of what it does, you obviously can't be public about. You can't talk about like where you're running spies and things like that.
And
because that would be
equal representation between Democrats and Republicans?
Closer.
Closer?
I mean, yeah.
And at least when I was there, no longer, it was a unified staff. You didn't have Republican staff and Democrat staff. Is it still unified?
They have different staffs, but I think but your broader point is true, that it's much less partisan than oversight of other areas of government. And I think there was a very, very productive working relationship between the intel committees and the intelligence community. I mean, it wasn't perfect, and obviously public hearings are different than private hearings, but the intelligence community and the intelligence committees work together very closely. There's a lot more regular communication between the intelligence committees and the intelligence community.
And am I remembering right? That was a product of the Church Committee?
Yes.
So this, I'm sorry, Frank Church was chairman of some committee and had these hearings into CIA activity and stuff. And then major legislation came out of that in which Congress asserted like the strongest supervision it had ever asserted over national security matters, right?
Yeah, so this is
Was that a good thing or not?
I mean, I think it's
On balance.
I mean, I think the bargain was, so basically what happened was post-Vietnam, when I think both the Vietnam War soured the United States, soured the people in the national security establishment, and there were a lot of revelations of what were perceived by the public as intelligence abuses, and I think most people would agree were intelligence abuses. The grand bargain, I think, that was struck was Congress passed a lot of framework legislation. They passed FISA, they passed the War Powers Resolution, and one of the things they did, I don't think this was necessarily legislation, probably was it was like chamber rules, was we'll set up these permanent select committees that will engage in much more intense oversight of the intelligence community. And the benefit of the bargain for the executive branch is like you'll still have an intelligence community who can do the things you think it needs to do. And for 50 years, it's allowed the intelligence community to still engage in intelligence activities. I think there's been times when there's been a disjunction between the intelligence community doing what the people believe is legal, but I think overall it's worked pretty well. Yeah. I think you're seeing stresses on it for the same reason you're seeing stresses on all the things we've talked about today. But I found it to be a productive relationship, and with both members and staff of both parties, we would have productive engagements about things the intelligence community needed. We would provide them information about important national security issues so they could relay that to other members and inform other members of Congress about it. So it is a model, I think, of how things can work better.
Yeah. So I want to give an opportunity if there are any questions for people to just come up to the mic. Chairman.
Thank you all so much for being here. Full disclosure, I did work with Professor Goodman on the Just Security Presumption Regularity project. He does not know what my question is going to be, though. Two things that have come up a lot kind of in this context of deference to the executive branch under this administration are, number one, conflicts between what the president or other high-ranking administration officials say and what's represented in court, and number two, the view that there's been politicization of the processes that lead to an argument being made in court. And in both, it at least strikes me that there's some tension with the modern version of unitary executive theory, specifically the Trump v. United States view. So I'm curious to hear whether you think that unitary executive theory, as it has kind of bubbled up through the modern Supreme Court, is playing a role in the behavior of the Trump administration, but also the way that it's being received in court. Thank you.
So I'll dive in on that. So I've actually, I'm glad you asked that question. I think about this a lot, believe it or not. So, and it relates to what we were just talking about, because one of the things that happens when Congress fulfills its oversight function over the executive branch is that actors inside the executive branch bristle at having to deal with it, right? It creates work for them. You know, this is the labor relations point that I think is an understated element in all of these questions. And so what they sometimes fail to recognize is that congressional oversight and Congress getting involved and creating, for example, additional procedures that a particular office might have to follow is empowering to that office, right? If that office has to go before Congress and explain itself, then that gives that office more power inside the rest of the executive branch, because they can say at the meeting, at the lawyers group meeting, right, at the NSC lawyers group, well, we're going to have to go defend this. And so it's actually going to be pretty important for us to be able to say X, Y, and Z. And we can't say that right now. And therefore, you're going to need to do this, right? So that's empowering, in fact. And I think people don't always necessarily think about it that way. And as a broader matter, actors inside the executive branch, these are not just executive branch actors. These are agencies that are created and funded by Congress. These are actors that Congress has sought to not only create these offices, but then regulate these offices and empower these offices, but also with legislation that comes with constraints. And by engaging and by following the rules of law, saying, oh, I'm not actually going to make that a W because it's a T, I'm not going to change that number, I'm not, right? These are actors inside the executive branch following congressional statutes in a way that might create some tension with their political overseers. And so is that, you know, some sort of deep state uprising from within, or is that executive agencies are actually not only executive branch agencies, but also creations of Congress? Executive branch actors are created by, funded by, and then protected by congressional statutes, not just the Civil Service Protection Act, but also whistleblower statutes and a whole range of other things. And then the question becomes, is the court actually going to protect all of that? Is the court going to protect congressional creations when the executive branch decides to just raise that office or that entire agency to the ground? Is the court going to protect particular actors that Congress has said cannot be removed without cause, for example? We already know that the court has been coming for those positions, right, and coming for those regulations. And the question will be, how far down do they go? Do they get rid of the civil service entirely, right? And if they do, then everything we've talked about with respect to Congress and the courts being able to defer somewhat to executive branch action, being comfortable leaving national security questions, for example, in the hands of the executive branch, all of that has historically relied, all of that executive branch aggrandizement has historically relied on the fact that there is some sense that nonpartisan experts are inside the executive branch exercising some of those functions, right? There's a reason that Democrats will vote for reauthorizing surveillance authorities for a Republican president and vice versa. And that is because there is an assumption that these are not going to be exercised in partisan ways, but rather going to be exercised with some sort of apolitical, nonpartisan, right, expertise. And so if all of that gets ripped apart, now, obviously, Congress is not going to immediately snap its fingers and change all of the statutes. But going forward, what it will mean is, for some period of time, we're going to have all of that power that Congress expected to be able to continue to regulate now entirely in the hands of one individual, right? And that's unsustainable as a democracy and as a, you know, and certainly for the separation of powers. I would say I'd prefer to live in less interesting times, right? And so we'll see what happens.
Hi there, my name is Aiden Arasasingam. I'm a 2L here. I was wondering, because a lot of the discussion focused on kind of the lack of regularity across the board and more in an aggregate sense, but kind of from popular reporting, it just seems like some agencies and departments are maybe have more process and more credibility than others, and some U.S. attorneys' offices have more process and regularity than others. And so just curious in kind of what you're seeing, is there like the potential for, is there the potential for more of a sliding scale of the presumption dependent on, who might be coming before the court from what department, agency, or U.S. Attorney's Office, or what issue might be before the court?
I don't think any of us are in the executive branch right now, so it's hard to speak on exactly what's different. I mean, I think your point is exactly right, that different issues come up. I mean, when I was in the executive branch, different agencies function differently. Some are more effective than others. Some run processes better than others. I think that's not just because of who's at the agencies. They have different missions that require them to have more process discipline or not. Like if you're in the Department of Defense, particularly in the uniformed military, you have to follow rules, and it's very different than being at the State Department, where
No rules.
not no rules, but it's like if you're performing a different function, so things operate differently, and the national security agencies operate different than domestic agencies. I think that's true. So I'm certain that it's still the case that agencies are operating differently now, and some of the concerns that have animated courts to raise concerns are more present in some agencies rather than others. I think the point you're highlighting is one of the reasons why moving from a retail to a wholesale approach to not having a presumption of regularity is so difficult, because agencies where that issue has come up, why should their behavior affect agencies who have nothing to do with it and are still operating in a regular fashion? That's why I think that it's probably going to remain under theorized and be just kind of a common intuition that judges apply based on what's happening before them. I think that's probably inevitably what's going to happen, because it would take so long to develop a doctrine and work that out, that I think that hopefully we'll be in the 6th or 7th inning, and a relief pitcher will be in, and things will be working a little differently by then.
Yeah, and also it's interesting, some folks at the Cato Institute have taken the data from their presumption regularity study and said, look at this, if you actually study it based on agency and department, it's ICE and DHS that are responsible for a lot of these court cases coming out with judges making these statements about misrepresentation or noncompliance. And as you say as well, Chris, if there were any wholesale, maybe be wholesale by department or agency, why would another department or agency have to suffer for what's happening from over there?
Well, and this ties us back to some of the earlier conversation. ICE and DHS, however you feel about what's going on, it's grown dramatically. Its mission has increased enormously in recent years. And I think that it seems logical to me that courts are going to provide more searching review of places where greater claims of authority and more innovative claims of authority are made than in areas where you're doing something that's basically consistent with what's been going on for a long time. And it's the way the law typically works. It proceeds analogically from precedent. And when we're stretching precedent further and further, I think that it's just natural to be more searching in your inquiry.
And I think one of the judgments that the courts will have to make is what we're going through right now an aberration, or is this the new norm? Because as you've been told this a lot in your young lives, this is not normal, what we're going through right now. This is not how things normally work. Now, you may be happy that it's not normal. The older ones of us are not. I'm not. So I think one of the real questions is, and that's why I say 3rd or 4th inning or so, is this the new norm, or is it just an aberration? Then we'll get back to the norm. And I hope it's the latter. I don't think this is a good way to do the rule of law. I think it's a good way to inspire confidence in the American public. So that's my hope.
And that's actually how I was thinking about even closing it out, that I've so appreciated this discussion. I'm sure everybody else has as well. And when you mentioned coming back in August, I think of the new semester, and maybe that's the 6th inning. So this discussion is so fruitful. I think it'd be just great to even kind of reconvene and see where we are at that time. But just want to thank the panelists for such an extraordinary conversation.
Thank you. I